The Senate will come back to order. For what purpose does the senator from the 17th rise?
Mr. President, I ask for unanimous consent that House Bill 426 be engrossed.
Mr. Secretary, can you please read the caption of House Bill 426?
House Bill 426 by Representatives Estration of the 104th and others, a bill to be entitled an act to amend Article 1 of Chapter 10, Title 17 of the Official Code of Georgia Annotated relating to procedure for sentencing and imposition of punishment so as to revise criteria for imposition of punishment for crimes involving bias or prejudice.
Chair recognizes the senator from the 17th to speak to his motion.
Thank you, Mr. President, members of the Senate. House Bill 426, we've talked about this bill especially a lot the last week. Some early mornings, late nights working through this bill. I think we have a version that we can get past, that everybody's had input in, and if we engross this bill, we can have our debate about the underlying bill and hopefully send this issue across the hall for debate. I ask for favorable consideration.
Senator has yielded the well. Senator from the 17th has asked for unanimous consent that House Bill 426 be engrossed. Is there objection? There is objection. All those in favor of the motion to engross will vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? Have all senators voted? Hallways clear. Please lock the machine. On the motion, the yeas are 29, the nays are 22. The motion has prevailed, and House Bill 426 is engrossed. We are now moving on to the rules calendar. Mr. Secretary, can you please? I would ask that all senators please take your seats, cease all audible conversations, and let's move on to the rules calendar. Mr. Secretary, please read the caption of House Bill 838.
House Bill 838 by Representative Hitchens of the 161st, a bill to be entitled an act to amend Code Section 24-5 5-510 and Article 8 of Chapter 2 of Title 35 of the Official Code of Georgia Annotated, relating to privileged communications between law enforcement officers and peer counselors and Office of Public Safety Officer Support, respectively, so as to change the name of the Office of Public Safety Officer Support to provide for related matters and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute. Senator Mullis of the 53rd District Chair. Mr. President, the Senate Committee on Rules offers the following substitute to House Bill 838, a bill to be entitled an act to amend Code Section 24-5-510 in Article 8 of Chapter 2 of Title 35 of the Official Code of Georgia Annotated, relating to privileged communications between law enforcement officers and peer counselors in the Office of Public Safety Officer Support, respectively, so as to change the name of the Office of Public Safety Officer Support to amend Chapter 8 of Title 35 of the Official Code of Georgia Annotated, relating to employment and training of police officers, so as to enact a Bill of Rights for peace officers under investigation, to provide for interrogation procedures, to provide for compliance review panels, to provide for the right to bring suit, to provide for the right of notice of disciplinary action, and for other purposes. Mr. President, Senator Robertson of the 27th District and others files the Amendment 1, offers the following amendment. Number 1, amend the Senate Rules Committee substitute to House Bill 838 by deleting lines 6 through 9 and inserting in lieu thereof the following. Peace officers, so as to provide for the right to bring suit, to provide for bias motivated by intimidation against first, and for other purposes. That completes the order, Mr. President.
Chair recognizes the senator from the 29th to speak to House Bill 838 and Amendment Number 1.
Thank you, Mr. President. Fellow senators, I rise before you today to talk about a piece of legislation that is near and dear. It's a very simple piece of legislation. The primary part of it is, if you'll read in Section 1, we've established a process so that public safety officers who we know suffer much greater percentages of post-traumatic stress disorder than the other parts of our non-military society. So what we've done is we've established this program. It was established on past legislation, and to make it more user-friendly and available to all of public safety, we have stricken the word officer in Section 1 and replaced it with, because the support that's given by these groups is given more than just officers. It's also offered to firefighters, EMTs, and others. And please understand that as I'm talking, I will be speaking to Amendment Number 1, because what we're adding by deleting lines 52 through 13 is that peace officers have a civil due process if anyone knowingly and maliciously files a false report against an officer, that the officer does have civil relief. And then in Section 6, we discuss the bias-motivated intimidation that currently exists and has for years in order to protect first responders. And I want to give the senator from the 56th the credit for that phrase of unity within public safety. And what this section does is it gives protection to first responders and their families from actions outside of the job that are related to explicit bias against those. And with that, Mr. President, I'll yield to any questions.
You have no questions.
Thank you. I yield the well.
For what purpose does the senator from the 6th rise? After he yielded the well, Senator. Does any other senator wish to speak for or against House Bill 838? Chair recognizes the senator from the 6th.
So I'll just address it from here since it really was just a question. And specifically, one of the concerns I have, or one of the questions I have, is that in terms of Section 5 of the bill, it indicates that whenever a peace officer serving in the state of Georgia under investigation and subject to interrogation by members of law enforcement agency for any reason that could lead to disciplinary action, suspension, demotion, or dismissal, the interrogation shall be conducted under, and then you've got kind of the Bill of Rights laid out under it for a few pages. My concern is that with respect to Section 5, the investigation or the interrogation does not have to be specifically as to an officer acting in their official capacity or duty. For example, an officer may be pulled over for a DUI. The Bill of Rights comes in. An officer may be accused of domestic violence or committing another crime outside of his official duties and or capacity. And then with respect to that, all of these kind of extrajudicial due process rights kicks in. So that was my question, because I don't believe the intent would be to do that, but the express language of this bill basically would do that whenever a police officer was subject to any kind of criminal investigation, and not just for an investigation relating to that officer's official duties. Thank you. I yield the well.
Senator has yielded the well. Any other senator wish to speak for or against House Bill 838? The chair sees none. Chair recognizes the senator from the 29th to close.
Just briefly, I respect the opinion greatly of the senator from the 6th, and just anyone with any questions, that is part of the amendment. The entire part she just spoke about was removed from the legislation, primarily with the support of the Sheriff's Association and the Chiefs Association. And with that, I yield the well and ask you to please support this legislation. Thank you.
Senator has yielded the well. We will take up amendment number 1 first. Is there any objection to the adoption of amendment number 1? The chair hears none, and amendment number 1 is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill as amended. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Got a couple more that need to vote still. All senators have voted. Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 33, the nays are 20. This bill, having received the requisite constitutional majority, is therefore passed by substitute. For what purpose does the senator from the 29th rise?
Mr. President, I ask that we move for unanimous consent to move House Bill 838 to the House for approval.
Senator from the 29th has asked for House Bill 838 to be immediately transmitted to the House. Is there objection? The chair hears none, and it is so. Mr. Secretary, can you please read the caption of House Resolution 1300? 1300.
House Bill 1300, House Resolution 1300, authorizing by Representative Perkel and others, a resolution authorizing the change of use of certain property located in Glenn County currently dedicated as a heritage preserve, authorizing and granting a non-exclusive easement for construction, operation, and maintenance, and for other purposes. Mr. President, the Senate Committee on Government Oversight recommends this bill do pass by substitute. Respectfully submitted, Senator Heath of the 31st District Chairman. The Senate Committee on Government Oversight offers the following substitute to H.R. 1300, a resolution recognizing the late Senator Jack Hill and renaming a state park in his honor, authorizing the change of use of certain property located in Glenn County currently dedicated as a heritage preserve and for other purposes. Mr. President, that completes the order.
Chair recognizes the senator from the 51st to speak to House Resolution 1300.
Thank you, Mr. President. Give me a second to get my paperwork here. Trying to pull a little whip duties here. House Resolution 1300 is the easements for the DOT. It's in Glenn County and Murray counties. It removes the Heritage Preserve designation for property in Murray County from heritage. And it also does a very important thing that we're all proud of, and that is the naming of Jack Hill State Park. As we all still anguish and feel sorrow for the loss of our brother a few weeks ago, we're going to do some things, hopefully over the course of the near future, to recognize all of the accomplishments that this dear man and this great leader left behind in this state. And one of the things is in this resolution. So we want to get 100% vote on this resolution, H.R. 1300, and we'll continue to remember the great works of Senator Jack Hill for all the great things that he's done for us. Mr. President, I'll yield the well.
Senator has yielded the well. Any other senators wish to speak for or against House Resolution 1300? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. Committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the adoption of the resolution? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the adoption of the resolution by substitute. All those in favor of the resolution will vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? Have all senators voted? Hallways clear. Mr. Secretary, please lock the machine. On the adoption of the resolution by substitute, the yeas are 52, the nays are 0. This resolution, having received the requisite constitutional majority, is therefore adopted by substitute. Mr. Secretary, can you please read the caption of House Bill 1098?
House Bill 1098 by Representatives Carpenter IV and others, a bill to be entitled an act to amend Title 32 of the Official Code of Georgia Annotated relating to highways, bridges, and ferries so as to provide for the development of a statewide strategic transportation plan, provide for updating and reporting such plan, to provide for use of such plan in making award determinations relating to public and private financing of projects and for other purposes. Mr. President, the Senate Committee on Transportation recommends that this bill do pass by substitute. Senator Beach of the 21st District, Chair. The Senate Committee on Transportation offers the following substitute to House Bill 1098, a bill to be entitled an act to amend Title 32 of the Official Code of Georgia Annotated relating to highways, bridges, and ferries so as to provide for development of statewide strategic transportation plan, to provide for updating and reporting such plan, to provide for use of such plan in making award determinations relating to public and private financing of projects and for other purposes. Mr. President, Senator Unterman of the 45th District offers amendment number 1 to the committee substitute to House Bill 1098 by adding section 1 and adding on line 58 the intersection at State Route 316 and Harbins Road as the Charlotte J. Nash in Gwinnett County and renumber accordingly. Mr. President, Senator Unterman of the 45th District offers amendment number 2 to the committee substitute to House Bill 1098 by adding after section 9, line 259, the following: the intersection at State Route 316 and Harbins Road in Gwinnett County, Georgia, as the Charlotte Nash interchange. This becomes effective January 1, 2021, and by renumbering accordingly. Mr. President, that completes the order.
Chair recognizes the senator from the 51st to speak to House Bill 1098.
Thank you, Mr. President. What you see before you right now is the annual housekeeping bill from the DOT. It's pretty straightforward and simple. The first section of the bill removes some antiquated language that was put in years ago for the planning department and the director of planning. That's been updated and is no longer necessary, so it removes that language from 2009 and updates the strategic transportation plan so that it can be delivered in the same frequency as federally required in their regulations. Section 2 enables GDOT to develop through rulemaking a process to protect and protest a rejected bid. If a low bid is rejected for a number of reasons, this allows a low bidder the opportunity to come in and protest the rejection of that bid and allows the DOT to give an explanation as to why that rejection was given for that bid. Section 5 and 6 of the bill deals with sound barriers. You see a lot of sound walls being put up around the interstates, especially here in the Atlanta urban areas. A lot of structures had to be moved and relocated. Sometimes the sound walls become an obstruction to those businesses and those structures. So this deals with how cities and counties deal with that. We dealt with this about 2 or 3 years ago. This is some cleanup language and additional language dealing with that. And Section 8 of the bill extends the sunset for 3 years dealing with the CPI. That's the Consumer Price Index for motor fuel that we put in HB 170 back years ago. And Section 9 of the bill makes it clear that GDOT is included along with all the other state agencies in Section 50-13-41, which deals with administrative hearings and judges and so forth. So, Mr. President, I'm happy to take any questions or yield the well.
Does the senator from the 45th have a question or wish to rise? Chair recognizes the senator from the 45th for a question.
Parliamentary inquiry.
State your inquiry.
No, I'm sorry. I have a question for him. I'm sorry.
Recognized for a question.
Sorry. I'm completely sorry. I was distracted.
You're confusing me.
Well, there's so much going on in here today.
I've heard that.
Busy day.
Yes, busy day. I'm sorry. Mr. Whip, my question is about these sound barriers. I know in Senate District 45, I think we've put 7 up. on Interstate 85, and it's to protect neighborhoods. Well, one of my questions is, if you put a sound barrier wall up and there's a billboard that's existing and that billboard has to come down, does this give permission to reinstate that billboard at a higher height so that it is more visible?
They would not be allowed anywhere in the residential area, first of all, so that's not pertaining to what your comment was about the neighborhoods and the sound barriers. It would be only in commercially zoned areas. It would allow those billboards to be relocated in that similar location. As far as the height goes, they would have to comply with the permitting of GDOT and the federal regulations that go along with that.
You have no more questions.
Thank you so much.
The chair recognizes the senator from the 45th to speak to amendment number 1 and number 2.
Thank you, Mr. President. I'm sorry for the confusion. At the proper time, I'd like to withdraw amendment number 1. It was written incorrectly, but I would like to speak to amendment number 2. And the reason I put this amendment into House Bill 1098, and I appreciate the author allowing me to do that as a committee substitute, is because I had asked, and I believe the senator from the 9th had also asked for a road naming to name an intersection after Charlotte Nash, who is the county chairman of Gwinnett County, which is my home county. And for some reason, I was asked by the chairman of the transportation that an existing elected official cannot have a bridge or road named after them. And I understand that rule of the Transportation Committee, and I accept that rule. But the way that I have written this amendment, this does not become effective until January 1st of 2021, and that elected official will no longer be in office. So the question becomes, well, why don't you just wait until next year? This is very, very sentimental to me. I served with Chairman Nash when she was my county administrator and I was a county commissioner. I also know that she has worked over 30 years for Gwinnett County as a Gwinnett County employee and then became an elected official. And I don't think the question here is to the suitability of her stature to be able to name the intersection, is the process. And unfortunately, this process has got some ambiguity. I'm leaving office, and I would like to see, and as a courtesy, I'm asking you as my fellow 55 senators to give me that courtesy that I've been elected in this body for almost 20 years. And if I could have this road naming, I've only ever done a few other road namings since I've been here. If I could have this road naming, I certainly would appreciate it and add it as an amendment to the bill. I'll be glad to answer any questions.
You have no questions, Senator.
Thank you. I ask for your favorable consideration, and at the proper time, I'll make the motion to withdraw amendment number 1. I ask for your favorable consideration to amendment number 2.
Does any other senator wish to speak for or against House Bill 1098 or the amendments? For what purpose does Chair recognizes the senator from the 21st? At the appropriate time, we'll take that question. Chair recognizes the senator from the 5th to speak.
I'm going to probably vote for this amendment.
Sir, state your, is this a parliamentary inquiry? Is this a parliamentary inquiry?
Yes. Yes.
State your inquiry.
Isn't it true that every senator deserves respect and a courtesy in this chamber?
Certainly, certainly we all are respectful of each other.
Thank you.
Thank you. Chair recognizes the senator from the 45th.
Parliamentary inquiry.
State your inquiry.
Is it not true that I would like to withdraw amendment number 1 and have consideration of amendment number 2?
I would be that to be true at the appropriate time, this is
I'd
the
like
time
to-
to make the motion.
Thank you. I'd like to make the motion to withdraw amendment number 1.
Senator from the 45th has asked that amendment number 1 be withdrawn. Is there objection? The chair hears none, and amendment number 1 is withdrawn. For what purpose does the senator from the 48th rise?
Thank you, Mr. President. Parliamentary inquiry.
State your inquiry.
Could we have a copy of amendment number 2, please, sir?
Secretary's telling me it's on the desks, but if we've got one up here for you if you'd like it. All right, now we're going to take up amendment number 2. The adoption of amendment number 2. Is there objection to the adoption of amendment number 2? There is objection. All those in favor of amendment number 2 will vote yea. Opposed, nay. The secretary will unlock the machine. For what purpose does the senator rise?
I thought I had a chance to speak. I apologize, but we have never, ever in the Transportation Committee named a road for a current elected official. We will take care of Ms. Nash next year, but we are setting a very bad precedent. And as the chairman of the Transportation Committee, I would ask you to vote no.
Chair recognizes, for what purpose does the senator from the 45th rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that this is effective on January 1st, 2021, and she will not be an elected official?
I believe the amendment speaks to that. Have all senators voted? We got one more coming down the hall. Don't hurt yourself. Take your time. The hallway looks clear. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the adoption of amendment number 2, the yeas are 15, the nays are 33, and the amendment is lost. The question now is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agree to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you read the caption of House Bill 167?
House Bill 167 by Representative Taylor of the 173rd and others, a bill to be entitled an act to amend Code Section 33-23-29 of the Official Code of Georgia Annotated, relating to authority of agent to act as adjuster, non-resident adjusters, and reciprocal agreements, so as to allow employees of licensed property and casualty insurers to adjust residential property insurance claims of $1,000 or less without obtaining an adjuster license and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute. Senator Mullis of the 53rd District Chair. The Senate Committee on Rules offers the following substitute to House Bill 167, a bill to be entitled an act to amend Chapter 1 of Title 51 of the Official Code of Georgia Annotated, relating to general provisions regarding torts, so as to provide for limited immunity from liability for the transmission of, contraction of, or exposure to COVID-19, to provide for legislative findings and for other purposes. Mr. President, the Senate, Senator Stone of the 23rd and others offers the following amendment number 1 to House Bill 167 as follows. Line 14, after quote, state of emergency, close quote, insert quote, as provided in this act, close quote. Line 24, after quote, thereof, close quote, insert quote, or, and for other purposes. Mr. President, that completes the order.
Chair recognizes the senator from the 18th to speak to House Bill 167 and the amendment.
Thank you, Mr. President. Good morning, colleagues, or afternoon it is. I am pleased to give you an opportunity to vote on HB 167. You know, we have all lived through COVID-19. It has changed our lives. It has changed our way of life. And it has brought significant uncertainty to all of us. Not just us in this room, it has brought significant uncertainty to our families, to our businesses, and to our state, as everyone in this room is keenly aware with what we've had to do with regard to just budgetary issues and the difficult decisions that we've had to make. But I want to take you back to the beginning of this COVID-19 outbreak and a refrain that was made certainly in Georgia and to some extent nationwide. And it was, we're all in this together. We are all in this together. While things are starting to wane and things are opening up to some extent, and we hope that we've got the worst of this behind us, although some predictions are that there's another wave coming and it doesn't look good and is greatly concerning. There is, in fact, something that we can do when we think about those days and think about the insecurity that was brought on by COVID-19 that is still here. So the question is there something we can do as legislators before we leave here on day 40 that improves this situation, improves the anxiety that is out there in our business community, that improves the concern that employees have that haven't been able to go back to work? And the answer to that is yes. And this is your chance. You get to vote on HB 167. It is a comprehensive pro-business, pro-Georgia, and pro-healthcare provider bill that's necessary to aid in our state's recovery from the COVID-19 crisis. To ensure economic recovery, businesses need the assurance that when giving their best efforts in dealing with the public to protect employees and the general public, that they in turn will be protected from frivolous lawsuits. Not any lawsuit, not every lawsuit, but frivolous lawsuits. As our public health officials learn more about COVID-19 every day, our recommendations continue to change. Businesses and the medical community need the support of our legislator, those of us in this room and across the hall, to provide a consistent and predictable legal environment as we move forward in post-COVID-19. The legislation does two things. Number one, it addresses COVID-19 exposure for businesses. And number two, it addresses the liability of our health care providers, many of whom y'all know were and are and remain and will be on the front line of taking care of us and our families and our constituents. This bill simply states that no cause of action shall exist for the transmission or contraction of COVID-19 unless the business or person performed a willful or wanton misconduct or the intentional infliction of harm. Think about that. That's the core of this bill, y'all. It simply says that there's not going to be a cause of action. Translation, you can't sue somebody if you get COVID-19 unless they intentionally did something to give it to you or cause you to have it, or if they were reckless. Additionally, the legislation protects healthcare providers, and I'm going to go through the bill in just a moment with some details. But it protects those healthcare providers that have been treating the patients with COVID-19, as well as the healthcare providers who had to make difficult decisions, some of whom are our very colleagues and are in this room. And they have aided our constituents in the difficult decisions during this COVID-19 crisis, sometimes with very limited circumstances and resources. So, small businesses in South Georgia who are worried about losing their life savings. Big businesses here in Atlanta are trying to figure out on what terms do they bring employees back and under what conditions. And the healthcare providers who are simply worried about being sued. We can provide them some stability and, very importantly, provide them some predictability. And that's, after all, what we kind of all want for our future days. Let me go through the bill. Section 1 simply acknowledges what the governor did with regard to his executive orders. Section 2 is just the name of the act. Section 3 really gives us the definitions and the heart of the bill. It defines COVID-19, which we have specifically and intentionally defined in a narrow fashion to address the COVID-19 virus. Not every malady, not every disease, not spin-offs, but this particular disease. It defines healthcare facility to encompass all of those that are a part of the healthcare system that have been serving us and our families. Defines a healthcare provider. Talks about who a person is. And then the heart of it, as I said a moment ago, simply says that there will be no cause of action shall exist for the transmission, contraction, or exposure for COVID-19 unless that exposure was caused by intentional act or conduct constituting willful and wanton misconduct. The second aspect of this really breaks down into two categories, and that is for the healthcare workers. Number one, it says that the healthcare facility or the healthcare provider will not be found liable unless in arranging and providing COVID-19 healthcare services, unless they are found to be intentionally inflicting people with harm, willful, or grossly negligent. So the standard is in the bill for our healthcare providers. This is not a free pass. This is by no means is this an immunity bill for healthcare providers. If those folks are grossly negligent, they stand to be liable under the law if this is passed. The second category found in subparagraph 2 of paragraph C says that for those healthcare providers that have been talking to and taking care of us, for those that gave advice to constituents and to us and our family and said, for example, you know what, if you're of such age and infirmity and you're in the high-risk category, and they gave advice that you perhaps should delay elective surgery or delay some surgery that you needed because they were fearful that you would contract COVID-19 while in the hospital, that judgment is protected as well. Again, not completely. If that judgment is determined to be grossly negligent, then there can be liability. That's, in essence, what the bill does. It gives the one thing that our businesses need, which is peace of mind and some predictability. It allows us, the predictability allows us and our businesses the ability to move forward out of this, to hopefully get our economy back started. It gives predictability, gives the ability to progress beyond COVID-19. And I know everybody in this room is desperate for that time that's coming sometime in our future. We just don't know when. And predictability also provides the healing that our state needs as we continue to recover. You've got some things on your desk. I won't go over them, but I think some are important with regard to what are other states doing right around us. Many states around us have passed similar legislation because they recognize the need to get our businesses going again. The Medical Association of Georgia, the NFIB, the Chamber, and others. You can read those. And they state better than I do why our economic recovery is so necessary. Finally, I want to speak to the amendment. I respect our judiciary chair who brings this, and I expect will argue it. There's just one real problem, y'all. It guts the policy of the bill that you would be voting on. There's a couple of things in here that are minor changes, but the problem is that when you change and you insert gross negligence, and you allow businesses to be sued for gross negligence, for catching COVID-19, you absolutely set the stage of uncertainty and unpredictability in a way that will keep businesses closed. They'll be scared to death to open. They won't know how to deal with their employees. Folks, just remember back a few weeks ago, the CDC was changing recommendations every 2 or 3 days of how are the healthcare professionals supposed to deal with COVID-19. I think we've gotten past those days, and we've gotten somewhat of a level of comfort, and the anxiety is fortunately subsiding. But think about, these are the very people that we hoped would be and wished would be at the hospital when we were taking our loved ones down for treatment and for care. These are the people that leave their families to go to the facility to take care of our families when we need that help. With regard to the businesses, if we're going to say grossly negligent, and by the way, folks, that is just one tick above plain old ordinary garden variety negligence. In the hierarchy of negligence and standards, gross negligence is just one tick above plain old negligence. And if that's what we're going to allow, if that's how we're going to interact with each other, if that's how we're going to treat our fellow citizens, and that's how we're going to look upon businesses, I think we need to search long and hard and rethink that. That sends the wrong signal. It says, hey folks, you better get ready for the lawsuits. When I first started working on this, I was told that there were billboards in California of lawyers saying, if you contracted COVID-19, call me. They want to file suit. And I thought, surely we're not going to have that here, but we do. We've got billboards in Georgia now, advertising. If you contracted COVID-19 or some family member did, give us a call. Do we want that visited upon our businesses? Do we want that visited upon our families? Is that how we're going to treat each other? Folks, this is a heck of a situation that we're in. Some people say, what, the worst since the flu of 1918? Let's do something to provide some stability as we move forward and navigate our way out of this. And this is the one way to do it. I appreciate your time and attention and consideration of this. It is an important piece of legislation. And to put gross negligence in here and say that that's all you got to have, and then the lawsuits come, that's not the message we need to be sending to business. It's not the message we need to be sending to our constituents. It's not the message we need to be sending out from this Capitol, I respectfully submit. So thank you for your consideration. I look forward to speaking at the end. Mr. President, I'll yield for any questions.
Chair recognizes the senator from the 31st for a question.
Thank you, Mr. President. Does the senator yield for a series of questions?
I do.
Is the Georgia Chamber of any significance?
Well, that sounds like one of those loaded questions, Senator. I don't know what you mean by that. Are they of any significance? I would say, depending on what kind of yardstick you're using, they represent a lot of businesses in this state. They represent a lot of businesses that employ a lot of people in this state. They represent general business interest. Do I think they're significant? Yeah, I think they're a significant voice down here, just as the many folks out in the hallway have people working for them, or the people in the hallway work for people that want those voices to be heard. I do think they're significant, yeah.
So is it true to say that they are powerful?
Senator,
representing these many businesses and so forth, as you just stated.
Senator, when you say powerful, I don't know in what context. Do you mean, are they powerful at the Capitol? I don't know. There's a couple of big initiatives they wanted this year that they lost on, so their power didn't appear to be very present earlier this year.
Would you agree that on the letter that you had placed on our desk and on the bottom of it, there is a statement that this will be a scorecard vote by the Georgia Chamber?
You're asking me, does the
It's
letter
the
say
fine
that?
print at the very bottom of the piece of paper that you had placed
Yeah.
on our desk.
Yeah.
Does that matter?
Yes, that is what it says, if that's what you're asking me, yes.
So then, isn't it true that this would be a quid pro quo? They have said, if you do this, we're going to do that.
Not at all, Senator. You have put a very, very contorted definition on the term quid pro quo, which I'm sure you know is Latin for this, for that. The inherent concept is I'm giving you something of value, you're giving me something of value. They're simply telling you ahead of time that this is an important issue to the Georgia Chamber. Your suggestion that somehow you're going to get something for this, that you're going to get something of monetary value, I don't follow your logic there. I don't think that makes any sense.
So what purpose would that statement be on here? I mean, we've determined that they're a influential organization. Their members are big business in the state of Georgia, and while they may not have got everything they wanted, they certainly have a strong voice at the state capitol. And whenever they tell you that if you vote yes for this, we're going to give you a green check mark on a document that we're going to send to all of our members and to anyone, probably posted on their web page, we're going to brag on you, but if you vote no, we're going to put a red X by your name and condemn you for your vote. I don't know how you define quid pro quo any better than that. It is something for something.
No, Senator, you're putting I've never heard the term or phrase quid pro quo used in that regard. As I said, it necessarily means something of value being exchanged, number one. Number two, I would tell you, I think that they're telling you on the front end that this is an important issue for them. And it's so important, it's a scorecard issue. Senator, with all due respect, you probably would complain if, in fact, it weren't on there and they scorecarded you on it. You would say, wait a minute, why didn't you tell me it was a scorecard issue? So they're telling you on the front end that this is a scorecard issue. And they're being informative and transparent. I don't understand what your issue is with being informative and transparent.
Thank you.
Chair recognizes the senator from the 42nd for a question.
Thank you, Mr. President. Will the senator yield?
I'll be happy to. Thank you.
Senator, early on, it was pretty early in your remarks, but I heard you say something like this would just apply to COVID-19 and not to any and all manifestations thereof.
Yes, Senator. That is, if you'll look, I think it's line 23, where it's the beginning of the definitions, which is paragraph A1, COVID-19 means, and then it is defined and it is drafted. Obviously, I don't have the medical background, but it is drafted for the purpose of limiting the applicability of this to the COVID-19 virus.
Well, so when I read line 24, it says any mutation or viral fragments thereof,
Yeah,
which to me suggests that that actually that is different than the way you represented it, because it could theoretically include any sort of related changes to it the way we typically have with many health conditions. It's very common for them to be similar but mutated, and then the viral fragments, it just, the definition to me seems much more broad in its applicability than just what we have been dealing with since December.
Senator, I understand the question and I appreciate it, but I respectfully disagree because you left off the word thereof. It is any mutation or viral fragments thereof, meaning a mutation of COVID-19, a viral fragment of COVID-19. The thereof necessarily ties it back to COVID-19. And as I think we probably all remember from the news reports, there are variations of this that all fall within what the medical community calls COVID-19. So I do think it's correctly refined, and I think furthermore, if we don't have that sort of language in there, now what you're going to have are multiple lawsuits, multiple tests, multiple experts saying, well, you know what, you got the March version of COVID-19, and that's what this addressed, but what we caught was the April version of COVID-19. It was a slight variation of that, and it's a different one. And that bill that the legislature passed to give us this predictability doesn't apply to me because it's a slight variation of that. And I don't think that's the kind of gamesmanship. I know that's not what you're wanting to do, and I don't think that's what this chamber wants to do, is to get in to set the model up for that kind of gamesmanship that would follow if we don't talk about generally COVID-19, provided it's confined the way it is.
So you led me right into my next question, which is when you look at section C, and it essentially says any person is arranging, any civil liability is covered for anyone who is arranging or providing COVID-19, and then now we're including any future mutation, offshoot, or viral fragment healthcare services, or the arrangement of healthcare services is impacted. Well, if this becomes something like a regular seasonal flu, which mutates every year, measles, which is still with us even though there's been a vaccine for decades, the way then I read that whole last paragraph in here is that essentially any civil liability for anything, because it could be impacted by future mutations, which will probably be occurring every single year for any provision of medical services, is all covered. So I see no limitation whatsoever on the civil liability that has been removed under your legislation, knowing what I know about seasonal illnesses, which granted is not that much, but I do see measles is still around after decades.
Senator, the chair will allow you to answer the question, and your time has expired after the answer.
Thank you, Mr. President. Senator, I appreciate the question, but again, I think you're ignoring lines 58, which says, such healthcare facility, healthcare provider, entity, or other person is arranging or providing COVID-19 related healthcare services. It is all tied back to COVID-19. And again, if you want to, sure, that's right, it does include mutations, because if y'all want to pass a bill that gives protection for the March 2020 version of COVID-19, okay, we will have done nothing for the businesses. We'll have done nothing for our state. But if you're talking about COVID-19 and its mutations, and again, that's why I think the words are very carefully crafted. It says, any mutation or viral fragments thereof of the COVID-19. That's what it says. And so I appreciate the question, but I think the language we have is clear. I think it's sufficiently detailed, and it specifically provides the parameters for this COVID-19. We don't want to pass something that simply is going to be worthless and useless next week when the next little variation of this comes along. Mr. President, thank you for the time you've given me, and I appreciate the time to answer questions. I'll yield the well.
Chair recognizes the senator from the 23rd to speak to amendment number 1.
Thank you, Mr. President. Fellow senators, I rise in support of Amendment 1. First, I want to say a little bit personally, I do appreciate all the risk that all of our healthcare workers that are in this body or in the House or that are family members of the chambers. My daughter is a fifth-year resident at University of Illinois in Chicago, and she has treated COVID patients, and her mother and I worry about her every day and keep her in our prayers. I favor this bill, the intent behind this bill, which is to limit liability, but I think it goes too far in several respects. And I'll go down my amendment and explain. It would help if you had the bill and the amendment in front of you, but if you don't, that's okay. On line 14, that's the fact-finding section. It makes it clear that the protections provided that should continue beyond the public health state of emergency are the ones as provided in this act. We're not incorporating any broad implied protections. We're focusing on what this act does to protect these institutions. Line 24 and 25 is in the definitional section. The definition of COVID-19, as has been discussed, it has to cover it from different angles. But the angle that it doesn't cover is that what we're defining as COVID-19 is what was the subject matter of the public health state of emergency that was declared by Governor Kemp. Not any more, not any less. So that tightens up the definition. Then moving down to line 50, and the meat of the bill is subsections B, C, and D. I'll mention something about gross negligence. Gross negligence is actually mentioned in the bill on subsection D, but for some reason it's omitted from subsection B. Now, what does gross negligence mean? The normal standard of liability is simple negligence, ordinary negligence. And that's the standard of care that a reasonable man should exercise in conducting his or her affairs. What we're trying to do is take it up a step to gross negligence. And that should be apparent not just in one subsection, but in both subsections. Gross negligence does away with the reasonable man standard and just basically says what someone who is not careful and would do. So that's quite a jump, and I'm in favor of that, but it needs to be stated in both places. Otherwise, you have a conflict, and you have the willful and wanton misconduct or intentional misconduct. That's tantamount to injecting somebody with COVID-19, intentional misconduct. Gross negligence deals with a standard of care, and that is far above what's generally required to prove a case in tort, which is just simple negligence. So we're giving our healthcare institutions a lot of protection by raising that level to gross negligence has to be shown. And we're making the bill more consistent by putting it in subsection B as well as D, where it already is. Moving on to line 51, and you know, one of the things I liked to do when I was in grade school, middle school, was to diagram sentences. I don't think they make students do that anymore, but it helps me greatly in figuring out the sequence of words. You need to, in drafting legislation, you need to say what you mean and mean what you say. Well, here's some ambiguity. Really, it's not ambiguous, but it injects ambiguity because it's in conflict with the other provisions. On line 51, we strike through the notwithstanding any provision of the law to the contrary, and instead insert except as provided in subsections B and D. If you leave it notwithstanding any provision of law to the contrary, you're saying ignore anything else that's in conflict with this section. And that's not what we're intending to do, not what I think our collective will as a chamber. We're trying to raise that standard of care, and to do so, we don't ignore standards of care altogether. Now, further down in line 53 through 55, I don't think we intended to make this a holiday for all negligence, even gross negligence. But if you read the lines literally, they read, healthcare providers shall have immunity from any civil liability for any harm or damages sustained as a result of an act or omission in the course of arranging for or providing health care services. That's basically a holiday from having to be responsible. That's not limited to COVID. But it goes on to say, including services performed in temporary or expanded facilities if the facilities were either engaged in something related to treatment of COVID or were supporting another facility that was engaged in something related to COVID. There's no causal connection between the COVID and the lowering of care. And that's what this amendment does by striking lines 57 through 62 and replacing them with this: such healthcare facility had a substantial impact on arranging for or providing such health care services that reasonably prevented the health care provider from satisfying the standard of care. It directly relates that COVID care to having to scramble to provide maybe a lesser amount of care or make some decisions that they would not ordinarily have made, like, for example, delaying elective surgeries. And sometimes that turns out to be a bad decision. But this at least ties them together and just doesn't say, well, there was some COVID treatment in this facility, and so as a result of that, there's immunity from all actions related to injuries, not just COVID-related injuries. Well, we correct that and put back a causal link. And all the healthcare facility has to show is just by a probable cause there was that connection between the COVID care and the lowered care or standard of care. The last thing that the amendment does is this is open-ended as it reads, but we've put a repealing clause in for July 1st, 2021. Now, if there's a second wave or a new emergency declared, whatever, we can deal with that, or y'all can deal with that. I won't be here to help at the next session. But this will get us through this extraordinary period we're in. We don't want to radically change all standards of care just because of an emergency which we hope will be temporary. Mr. President, that's all I have. I'll be happy to entertain any questions.
Chair recognizes the senator from the 45th for a question.
With the Senator Gill, Mr.
Yes.
Chairman. Mr. Chairman, I believe I was looking at that line, and you were basically talking about a blanket immunity. Was that on line 33? Could you just explain that one more time?
Well, where I was looking at were the lines that began in the 50s. I read from 53 through 55, but that was just to shorten it, to cut out surplus verbiage. But I'll read it to you the way the amendment would change it. With the amendment, subsection C would read, except as provided in subsections B and D, any healthcare facility, healthcare provider, entity, or other person that has legal responsibility for the acts or omissions of a healthcare provider shall have immunity from any civil liability for any harm or damages sustained as a result of an act or omission in the course of arranging for or providing health care services, including those in expanded facilities. That's blanket if I've ever seen it. Now, I will say this, that subsection D does try to indicate that immunity is limited by gross negligence standard. But you see, that injects ambiguity. This would be a very difficult law if enacted without the amendment for judges to understand. It would be confusing.
Would you further yield?
Yes.
I appreciate that explanation, and that's the way I understood it also. My next question follows the questions from the senator from DeKalb County, because the author of the bill, when he was up there, was talking about this bill was written very narrowly. And I think that just disputes what you talked about with the blanket immunity. But also, if it were written very narrowly, wouldn't it have a date in it, just like your amendment does? Your says, and shall stand repealed on July 1st, 2021. So if it truly were narrowly written, wouldn't that be included instead of saying in infinity?
Yep.
I mean, there is nothing that says, right, is that not correct, that this stands repealed on this day. But this is going to be the new law in the state of Georgia, right?
Right. This is, in effect, taking advantage of a temporary emergency to make broad, long-lasting changes, when really, if it doesn't occur within the effective time of this statute, the infection or whatever, then it shouldn't be a variance or a deviation from the law that our courts are comfortable with and know how to apply.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Does the chairman yield for a series of questions?
Yes.
Isn't it true during this pandemic, we senators were on weekly conference calls with the governor and many on his staff to talk about the situation across Georgia?
Yes.
And isn't it also true, and correct me if I'm remembering incorrectly, that there was at least one facility in which the governor had to call out the guard to go to that facility to basically clean the facility, and that there was some people that didn't want them in, and the guard had to go in to do it. Isn't that right?
I believe so. The guard was tasked with cleaning up all of our nursing homes.
And so when we look at immunity, and you talk about whether you're absolute immunity where you can't be sued versus gross negligence, which I agree with Mr. Chairman, that is still a high standard for someone to be able to sue. Aren't we affecting people's activity or incentive to follow the law?
Oh, absolutely. One of the purposes of tort law in general is to help clarify for society the standards we expect and hold people to them.
And when you further agree that absolute immunity means, you know, I as a company can do whatever, and in fact, I don't have to listen to the guard if they come out because I'm going to have absolute immunity from being sued no matter what I do.
Yeah, we ought to be very careful when we confer absolute immunity in any context.
And thank you, sir, that this amendment that you've worked on with others, and I know many in this chamber who are not on these papers have worked on this issue extensively, is a good balance, because gross negligence is still a very high standard, correct?
Right, and this makes it the standard throughout the bill, not just in one section.
Yes, sir.
I commend the efforts that went into this, and particularly the chairman of Public Safety who wrestled with this in House Bill 218. I tend to think that these kinds of bills need to come through a committee like Public Safety or Judiciary, because we don't get to flyspeck things when they come just from rules. No offense to rules, a lot of good things come out of rules, but that's the gatekeeper committee, not the getting down in the weeds committee. I'll be happy to answer any further questions. If
Chair
not,
recognizes the minority leader for a question.
I'll yield.
Senator, we look at today's society and we all depend upon those people working in the grocery stores, helping our food supply chain. Is it not true that, this would create such a high standard that someone would almost have to intentionally go cough on, willfully and wantonly go cough on somebody intentionally when they had COVID, but not offer just reasonable protections to workers like, PPE when possible, or telling them when somebody else might be ill, or just stuff that workers would expect and customarily in our society feel is fair and right?
I think so. I can't comment on workers' rights because you do have workers' compensation, but for other people, patients and possibly visitors or people that come in, suppliers, everybody needs to have some standard of care.
Further on that question, you mentioned workers' compensation. That might help you medically and some compensation to your medical stuff, but again, someone's life is important. I mean, you can't get that back if you've been willfully and wantonly exploited in that manner. Is that not true?
That's true.
You have no more questions.
Urge support for Amendment 1 and for the bill.
Chair recognizes the senator from the 6th to speak to House Bill 167 and Amendment Number 1.
Thank you, Mr. President. I concur with everything that the chairman just indicated, but there are other things I wanted to just point out with respect to how the bill is drafted. The sponsor indicated that it was very carefully drawn. I would submit that that is not the case. And specifically, I think there may be even issues with the two subject matter prohibition that would make it unconstitutional. Now, why do I say that? It's because the bill purports to be about just tort liability and dealing with tort liability. But the use of the term any civil liability that results in harm or damages actually includes contract damages as well. And so it's one of those things that, because of the way that this bill was drafted, first, I think you have some constitutional issues, And then secondarily, I think we need to be careful with respect to contractual claims where you can have a business-to-business dispute where one may owe money to the other on some kind of contract, and that business not being able to actually recover with respect to that contract claim. I also wanted to just point out in terms of how broad this is, on line 26, it defines healthcare facility. And then it starts on 29, and it says healthcare facility shall also include all related parties, including individuals, business corporations, general partnerships, limited partnerships, LLCs, LLPs, joint ventures, nonprofits, for-profits, not-for-profit entity that owns or controls said facility, is owned or controlled by said facility, or operates under common ownership. And with respect to that, as we know, and especially with large healthcare systems now, there's a lot of common ownership and common control. And so in terms of the application of this particular bill, for example, let's talk about the nursing home situation in our state where we have these large nursing home systems. The way this bill is drawn currently is you could have in DeKalb County a nursing home where they have COVID in that nursing home, right? The same nursing home system can have another home down in South Georgia. In South Georgia, somebody hurts one of the residents of the nursing home. Not intentionally, negligently, right? Drops the resident breaks a hip and ends up dying. I mean, there's all kinds of things that we know can happen in these nursing homes just from neglect. Because of the common ownership between these two nursing homes, even though nursing home 2 hasn't been impacted by COVID at all in terms of their facility, because of the common ownership or control in terms of this large kind of network, they basically get immunity for not caring for the most vulnerable people in our state. So with respect to that, I think that the way that the words are on this page and how this was drafted, I think that there are incredible unintended consequences with respect to that. I think that we all absolutely appreciate the healthcare providers who have been putting their lives on the line, and that's why the governor has entered executive orders that have extended immunity to these healthcare providers. But with respect to kind of going from here, and especially expanding it to all of these different facilities, could even impact contract claims, and then on claims that have nothing to do with COVID-19 or transmission, I submit to you that I think that that would be a major error in judgment. Thank you.
Senator has yielded the well. The chair recognizes the senator from the 1st.
You know, usually I don't get up here and talk about, lawyer bills. This is one of those exceptions. I will tell you, it is personal, for me. I, along with Chairman from the 40, can't see the number back there, but the Chairman of Finance, have been in rooms with COVID patients, have taken care of patients with COVID, have dressed from head to toe, wearing gloves, wearing a face mask, and wearing a shield. This is personal. Some of the information that has been said from this well has not been factually accurate, and I would expect more of us. Absolutely, it is not what was the term, absolute immunity. It is still, you're still being able to be sued, and that's what it's about really, isn't it? You're asking to be sued. Let me tell you, the hospitals and healthcare providers have been doing the best that we can. It has been fluid. It has been changing. And to say this emanated from the rules is just not factually accurate. We heard this in insurance. We debated this. We discussed this. It came out of the committee process. It did not come from rules. And it is not absolute immunity. And I will tell you, as a physician who has taken care of COVID patients who have passed away, who have counseled many people in this room who've had COVID, who've taken care of patients that are not allowed to walk into our office, but we have a shed that's, I should say a tent, that has tested over 2,000 patients. We've changed from a tent to a shed because there's so many. And you know, this is going to continue. And it's not going to be over when the executive emergency is over. Unless we test everybody twice a week for maybe 6 weeks or so, we're not going to drive it to zero. We'd have to shut the borders down. You're correct. We are going to have a smoldering case throughout until we have a vaccine. And yes, we should be wearing face masks, and we should be protecting ourselves. We should be protecting others. There's no doubt about that. This bill is a good bill. It is intentioned correctly, and I urge your support of the bill and voting down Amendment 1. Thank you. I yield the well.
Chair recognizes the senator from the 18th to close debate.
Thank you, Mr. President. I'm going to go out on a limb here and tell you I think this is probably one of the most important bills we're going to pass or not pass this session. And if we pass it, in what form is incredibly important. We're going to send a message across the state to people like the senator from the 1st, who's been in the trenches, who suits up, who puts on all the garb to take care of us. And you want to weaken this bill so that we can sue him because he doesn't operate to perfection? Is that how we're going to treat the people that we hope are there when we take our children in for treatment? I hope not. I really, really hope not. I want to address some of the comments made by the senator from the 23rd. The statement issues with regard to why is gross negligence in subsection D, but it's omitted from B. That's specifically in there, folks, because notwithstanding how much we need to support our health care folks, we also recognize and drafted the bill so that if they behave and if they give you care that's grossly negligent, they can be sued. But how do we want to look at the rest of society? How do we want to look at our fellow constituents, our fellow Georgians, people that are trying to open businesses, our employees that are going to come in? Are you going to set the bar so low that they know there's a great chance of being sued? The billboards are already out there. They're already there. So what's the problem with gross negligence? The problem is a year or two from now, it's going to be viewed with the benefit of hindsight. Businesses will always be judged by, well, did you do everything you could at the moment? That's not the standard that we find ourselves living in right now under COVID-19. You heard the senator from the 1st to talk about tents. Before COVID-19, if any of us had thought we would go get treatment at a tent, well, how long after COVID-19 is it going to be before somebody makes the argument, folks, that's just grossly negligent to see people in a tent? Why would you have doctors see people in a tent? There's germs, there's all kind of things that can, that's grossly negligent. But you know what? Everybody in this room was praying there'd be a tent at the location when we were told go down to a certain place because there's a tent with some doctors that are there to treat you. You wanted that tent, but 2 years from now, it's going to be deemed to be grossly negligent. Is that the standard we want to set up? With all due respect to the senator who said this is a holiday from liability. It is absolutely not that. And I think the senator even acknowledged that if you listen when he said that he was in fact focusing on lines 53 through 55. But all of that language is modified by lines 58, where it says, such healthcare provider, entity, or other person arranging for providing COVID-19 related healthcare services. It does not say, it does not suggest all medical services or all medical treatment. It's limited to COVID-19. Read it all in context. Let's be fair in our reading of this. Line 57 specifically says it must be tied. Well, let me ask you a question. One of the arguments made was that, is it in fact, does it have to be tied to COVID-19? Well, with regard to the trying to provide doctors protection and our nurses protection, but specifically the easy example is the doctor who said, you know what, we need to delay your treatment. What the language that's being provided by the amendment would say this: if in fact it's later determined that there wasn't any COVID-19 at the hospital where the doctor feared you might catch it, then it doesn't apply. You don't get the immunity. And again, we know it's not immunity. The doctors and healthcare providers don't get the protection. But the doctor advised you to postpone your surgery because he didn't know that at the time. You see, the benefit of hindsight allows us to kind of live in a perfect world. But that's not the world we live in. Why would we repeal this if in fact this is going to be the standard of how we treat folks, encouraging businesses to get back in business, and this is how we're going to treat our healthcare folks? Why would you repeal this? There's absolutely no reason except to say, hey, for you folks that want to go out and sue somebody, you're just going to have to wait. Check out your date here. Whatever day of the week that is, on a Tuesday, on Wednesday, start filing your lawsuits. That's all that is intended to do. The suggestion, and I think the good doctor in the chamber from the 1st District addressed this. This has in no way absolute immunity. The bill doesn't do this. Read the bill. It has standards for which folks can be liable, businesses as well. The comment was made by one of the senators that this includes contract claims. Contract claims are not covered in this bill. Again, read the bill. And then there was a problem, well, what about the definition of the healthcare facility? Folks, healthcare facility is defined the way it is to be as broad as it can because so many different hospitals, medical practice, healthcare facilities practice under different corporate structures. We're just trying to make sure that all of those are in fact afforded whatever protection is intended to be afforded by this, not just certain type of corporate structures. You know, again, I think the senator from the first comment about the tents, you and I wanted that tent to be there. If this gets worse, I hope that tent is there when I need to take my children down for some protection. And it really rang to me when the senator from the first said, you know, the hospitals, we're doing the best we can. They're doing the best they can. They've done the best they can. Let's make sure we're fair to them and don't expose them to untold lawsuits because someone's later going to figure out they could have done what they were doing a little bit better. They could have done what they did in a way that was somehow better. What happened, folks, that we're all in this together? You've got a policy decision to make. It's going to be very telling as to how you think we're going to treat each other in society, how we're going to look upon businesses. Are we going to encourage businesses to get back in business? Are we going to encourage folks to be able to return to work? They can't be reckless. They darn sure can't do anything to intentionally cause COVID to be transmitted. But if it happens, let's not set the table so that they're primed and ready to get sued by the folks running the billboards. Thank you, Mr. President. I yield the well. I encourage you to please vote no on the amendment and vote yes on the bill. Thank you.
All right, we're going to take up amendment number 1 first. The question's on the adoption of amendment number 1 by the senator from the 23rd. Is there objection to adoption of the amendment? There is objection. All those in favor of amendment number 1 will vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? We got one more? All senators voted? Mr. Secretary, please lock the machine. On the adoption of amendment number 1, the yeas are 24, the nays are 28, and the amendment is lost. All right, we'll take up the measure. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 31, the nays are 19. This bill, having received the requisite constitutional majority, is therefore passed by substitute. For what purpose does the senator from the 51st rise?
Mr. President, I ask for unanimous consent to transmit House Bill 1098 immediately to the House.
Mr. Secretary, please read the caption at 1098.
House Bill 1098, a bill to amend the statute related to highways, bridges, and ferries, development of statewide strategic transportation plan, and to provide.
Senator from the 51st has asked that House Bill 1098 be immediately transmitted to the House. Is there objection? Chair hears none, and it is so. The chair recognizes the senator from the 18th.
Thank you, Mr. President. I would ask unanimous consent to immediately transfer HB 167 to the House.
Senator from the 18th has asked that House Bill 167, which just passed, be immediately transmitted to the House. Is there objection? Chair hears none, and it is so. Chair recognizes the majority leader.
Thank you, Mr. President. I move that the Senate table the following bills on the rules calendars: HB 1094, HB 1093, HB 1003, HB 337, HB 463, HB 998, HB 1008, and HB 879.
The majority leader has moved that the following bills, H 1094, 1093, 1003, 337, 463, 998, 1008, and 879 be placed on the table. Is there objection? There is objection. There's no debate on the measure. We'll go to the board. All those in favor of tabling the pre-mentioned bills? Secretary needs a second to load this. All right, the majority leader has moved. There's been an objection. All those in favor of tabling the pre-mentioned bills, please vote yea. Opposed, nay. The secretary will unlock the machine. For what purpose does the majority whip rise?
Inquiry.
State your inquiry.
Isn't it true that this vote is a green button to table and a red button to not table?
The whip knows of what he speaks.
Thank you. Just for clarification.
Have all senators voted? Have all senators voted? Mr. Secretary, please lock the machine. On the motion, the yeas are 44, the nays are 5, and the previously mentioned bills are placed on the table. The next bill on the calendar is House Bill 426. Mr. Secretary, please read the caption of House Bill 426.
House Bill 426 by Representative Estration of the 104th and others, a bill to be entitled an act to amend Article 1 of Chapter 10 of Title 17 in the Official Code of Georgia annotated, relating to procedure for sentencing and imposition of punishment so as to revise the criteria for imposition of punishment for crimes involving bias or prejudice, to revise the sanctions for such crimes, to provide for manner of serving such sentences, and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute. Senator Mullis of the 53rd District Chair. Mr. President, the Senate Committee on Rules offers the following substitute to House Bill 426, a bill to be entitled an act to amend Article 1 of Chapter 10 of Title 17 of the Official Code of Georgia annotated, relating to procedure for sentencing and imposition of punishment so as to repeal certain provisions regarding the sentencing of defendants for crimes involving bias or prejudice, to provide criteria for imposition of punishment for defendants who select their victims based upon certain biases or prejudices, to provide the sanctions for such crimes and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute. That completes the order.
Chair recognizes the senator from the 46th to speak to House Bill 426.
Thank you, Mr. President. It is truly a privilege to be before you this morning. It is an honor to be a participant in this historic moment. We have heard many, many things about hate crimes, about the civil unrest we've been dealing with here for the last several months. It has brought this issue to the attention of all of our legislature, of all of our citizens. It has been in our face. And there are people on all political persuasions, all corners of this state, that are feeling very unsettled, very uneasy, very angry, very dissatisfied, very worried about our state, about our relationships with each other, about our image, about how welcoming we are for business, about our desires to treat everybody fairly, and our sometimes failure to do that. We have a long history in Georgia of embedded discrimination. We can't deny it, we can't run from it, but we can change it. Will this bill change the hearts and minds of Georgians? No, that comes from inside every individual heart. But can it send the sign? Can it send the message that Georgia is too busy for hate? That we intend to treat each other fairly and justly, no matter what your characteristics may be? Are we willing to be loving to each other? I think so. I think the time to pass this bill is right now. We don't stand for hate. Every one of you knows that. But we are sending messages out that we tolerate it. I think that we're at a really sort of a tipping point right now. And this has been brought about by some of the recent events that have been visually put in front of us on video that are impossible to defend. Now, we have heard for years and years about unfair treatment of people by law enforcement, by each other. And many times we just deny it. We ignore it. We say, nah, that's just those few bad apples on each side. That, you know, that's always going to be some folks that are haters. But we can make a statement that we don't stand for that. And we can encourage others to cease that behavior. This law isn't going to magically make everybody's hearts pure and loving and erase stereotypes, erase biases, erase prejudices that some will continue to hold. But in this continuum of history, we are evolving, we're moving forward, and we're moving forward together. There are certain types of past discrimination, starting from slavery up through Jim Crow laws, up through what some call institutional racism that have carried on through the years. Treatment of African Americans in this state has improved greatly over the years, but we're not there yet. We're not to full equality. We're not to full justice. We can move the ball further down the field with this. I read something recently, and I can't remember where. I just absorb everything like a vacuum cleaner, reading news and current events, but it said something to the effect that if you stand idly by and tolerate hatred, discrimination, you are part of the problem. That was a little bit of a gut punch to me, because me and many of my friends, we're enlightened, we're not racist, we don't buy into these stereotypes, we're beyond that. In my family, we taught our children, as soon as they were old enough to talk, we don't say the N-word because that is offensive. My wife, Amy, taught my children, we don't say hate in this house. Some child would say, I hate that, or I hate you. That's when you yanked them up, popped them on the butt, said, we don't talk like that. And so I look at the world and say, yeah, there may be some racist out there, but that's not a common problem. Well, maybe it's more common than we wish. And maybe if we continue sitting idly by, it continues to grow and fester and be an infection on our society. Maybe we engage today in a bipartisan manner, and we say we want to make the statement that that's not us. We don't stand for that. We don't tolerate that. We will no longer stand idly by silently and tolerate it, because to do so is to implicitly support it. And I just speak of one category here, one type of prejudice, bias, because it is something we've all lived with. It's around us. We had the great senator from Macon just the other day that held up his hand and said, I can't change this. I can't change the color of my skin. And it is unfair for me to treat him differently because of that characteristic. Makes him no less of a man than me, no less of a senator. We don't feel that way. We don't support that. Let's don't act that way. Let's make a statement. All right, so I grew up in Macon, the home of Capricorn Records and Southern Rock and Roll, home of Otis Redding, Little Richard, the musical mecca. I then go to Athens, another musical mecca now, that the home of REM and Widespread Panic, many other fabulous groups out of there. And so I am a music nut. I listen to it. Love the lyrics, love the music. Nothing more fun than me. Somebody quoted recently in here a song by Harold Melvin, Wake Up Everybody. He might have sung it, I can't do it. But there's a line in there that resonates. Hope I get it right. Don't violate any copyright laws here, but I believe it says, no more backwards thinking, time for looking ahead. That's the time we're at now. There's a Bob Dylan song for those of you children of the 60s and 70s, Blowing in the Wind, one of the most famous folk songs of all time, a protest song in the 1960s, and things hadn't changed. We're still protesting. How many times can a man turn his head and pretend that he just doesn't see? We can't do it. We see it. It's in our face. It's time to act on it. There are many other examples you can think of that get your attention. There were times in the 60s where there were violent clashes as we were evolving as a society. Georgia, certainly up until recently, has believed in and exercised nonviolent protest. Martin Luther King Jr. taught us the way, that you can be heard, you can make your point, and you can do it in a civil and respectful way and successfully achieve your objectives. In fact, there's nothing more powerful than watching MLK and John Lewis and others march across that bridge in Selma, Alabama, and be violently attacked by guard dogs, by fire hoses, and all of America suddenly woke up and said, whoa, now we see what he's been protesting. We see the injustice. It is a video image in our face. We're seeing that again today, and we're seeing anger from people that feel that they're being treated unjustly. As Mayor Bottoms said, though, this is not the Georgia way. Stop it, people. Be respectful. Stop breaking windows and throwing rocks and lighting fires. Make your voice heard, and our legislature will listen. Do it in a respectful manner, and it does seem that things tone down quite a bit there. And I hope we continue doing that, because it's better for all of us in our society that we air out our differences and we work collectively together to reach solutions. The journey of House Bill 426 has been long and arduous. It didn't begin last year. It began in 2000 when Georgia did pass a hate crimes law. I'm really tired of hearing that Georgia's one of only 4 states that doesn't have a hate crimes law. We were ahead of the game. We had it 2 decades ago, but unfortunately it was stricken down by the courts as being too vague, too ambiguous, unenforceable, not giving fair procedural notice of a defendant what he was doing wrong, or she, what was in violation. There have been numerous attempts over the years. My good friend Vincent Fort, past senator from here, introduced a bill almost every 2 years. And we kept working with it and trying to get it right. One year I led a study committee to try to look at it and figure out a way to solve the conundrum of making it definite enough and fair enough to one accused that it would be enforceable in court. This has brought it back to the surface and required quite a bit of working to try to perfect the language of this bill to get it right. We also had quite a bit of negotiation between the majority party and the minority party, where everybody came together to try to find a way to make this bill fair and address the problems that are necessary. There are several currents running through us at this time. What is probably setting people off worse than anything are these very vivid visual images of police interactions with citizens that seem unjust and unfair and unreasonable. You noticed I said seem. They seem that way to me from what I've seen, the video images I've seen, personal experience of representing clients who have been shot in the back while running. I have a current case with a young Caucasian shot in the back by an African American sheriff's deputy. It's not racial. You're seeing instances where African Americans are being treated roughly or excessive force being applied by officers, sometimes African American officers, sometimes Caucasian officers. Depends on, I guess, what category you're in or what group you belong to, how much you react to it. And I have learned from talking with my African American friends, Bill, don't you even think about saying, I know how you feel. I don't see color. I can't say that. I don't have the standing to say that because I have not been in your shoes, been in your skin, walked that mile in your moccasins to really understand it. But I'm trying to. Our senator from the 9th had a beautiful editorial in the paper Sunday, and he talked about listening. He said, we all need to listen to one another and be receptive to look after the needs and concerns of our constituents, no matter what nationality, sex, race that they are, because only by listening to other people can we figure out what the problem is and how to address it. So we're trying. If I say anything offensive, I don't mean it. I recognize my deficiencies. But back to my point, the first current we're dealing with is our interactions with law enforcement. We have a social compact with law and order. In this room, we pass the laws that we deem to be inappropriate behavior. That's so unacceptable that we're willing to punish people for it, to fine them, to put them on probation, to make them lose their freedom and be confined for a period of time because it's unacceptable conduct. We also need to make sure that we know the rules between law enforcement interactions with us as citizens. That's one of these currents. This bill doesn't address that, but you'll see on the consent calendar tomorrow a study committee resolution to create a study committee of the Senate to look at police practices, procedures, use of force, and discipline, no-knock warrants, chokeholds, whatever we think we need to investigate, because it's my firm belief is we need to know the lay of the land, the rules of engagement, so to speak. What is permissible by law enforcement? What should citizens expect? And what should law enforcement expect? Can you imagine the morale problems that a police officer might be experiencing right now, or a fireman, or a first responder? It will give them satisfaction, certainty as to what is acceptable use of force, so they don't have to fear they're going to be prosecuted and fired and jailed themselves for doing what they think is necessary to enforce these very laws that we are looking at. We're going to be in a mess if every jurisdiction, every city, every county starts enacting their own rules. It needs to be uniform statewide. And I wish that I had the time and energy and bandwidth left in these last 5 days for us to agree on all those things and codify it right now. But to do it justice, to do it fairly, it needs very thoughtful, deliberative study. But that's a part of this problem, and I think it's the one that was the match that lit the tinderbox here. And I would like for you all to join with me in finding the solutions to create a social compact with law enforcement that every citizen and every law enforcement officer agrees with. I'm pleased that the minority whip has joined me as a co-sponsor in that study resolution, and I want to tell the people of Georgia we are going to get a handle on this. But for now, please listen to Mayor Bottoms. Listen to Martin Luther King's guidance of nonviolent protest. Let's don't be the people that throw rocks and stones and bottles at firemen coming to put out a fire. Let's not be jumping up and down and burning police cruisers. Let's don't attack police officers and throw urine and feces on them when they're trying to maintain order so that you can exercise your right of peaceful protest. Let's set that aside for today with the agreement that as part of this package of bills that are moving here through this body today, we will address that thoughtfully and deliberately for the good of all. Second waves of currents coming through are interactions between citizens. And that's what we're talking about with hate crimes. The Lieutenant Governor's version of this bill really more specifically identified those as crimes of bias, prejudice, and intimidation. Because that's why it should be either an additional crime, like we just passed this morning, the first bill out was under that structure to say, if you take violent actions against first responders, EMTs, fire people, law enforcement, that behavior itself is such a violation of our civil trust, so destructive of law and order, that it should be a separate offense. But it was required in the language of that many of us passed, certainly the majority in this body, that the action be taken with the intent based on bias or prejudice to intimidate that victim and everybody else in that group. So when you attack a police officer or a fireman when they're doing their job, they're not the only victim. The entire profession then becomes the victim. And how are we going to keep people that are willing to serve and put their life on the line every day? So you see how we kind of have all agreed that there are certain crimes that, because they are really aimed not just at the individual victim, but the group that that victim belongs to, that it's entirely appropriate to either make it an additional crime or to enhance the penalties for it. I am a fan of the Lieutenant Governor's proposal here that created a separate crime for all these hate crimes. That is not what's in the House version, and that is not what you're voting on here today. This bill simply calls for enhanced minimum penalties if you commit a crime, and these are crimes that are already on the books. They're already criminal actions that we've passed, but if you're doing them with malicious intent directed at a certain group. And in the bill, we list those groups. And I can direct you to the very top of the second page, line 26. This bill prohibits you from committing crimes that we've already defined, many crimes, and you have selected your victim or group of victims based upon their race, their color, their religion, their national origin, their sex, sexual orientation, or gender. We put them all in there because there's so many different definitions of all of those. A recent Supreme Court case helped us with some guidance, but we wanted to make sure people understood that. Or your mental or physical disability. So those are the groups of people that we don't want crimes committed against them that have the effect of intimidating that entire group. These type of laws have been upheld to be constitutional in other states, in other areas on the federal level. And the reason is because in addition to harming the individual victim, they have the effect of intimidating an entire group of people. And the very natural result of that is fear amongst that group, that more crimes might be committed against them solely because of them belonging to whichever of these groups means the most to you or you're a member of. It also results in retaliatory crimes often. People fight back and they strike back and sometimes and say, we can't take this oppression, this abuse, and it makes them act out, and it causes civil unrest and widespread civil disobedience. Those are the provisions put in the Supreme Court decisions that upheld these. Well, man, have you seen that happening recently? Every one of those things. Inflicting emotional harm and fear on entire groups of people, provoking retaliatory crimes, and inciting community arrest. Every single one of those things we have seen happen in our state and each of our little cities and towns in the last 2 or 3 months. I had a testy exchange with the minority whip in our Judiciary Committee. And people asked me later, they said, wow, y'all really were going at each other, weren't you? And I said, you know what? I admire the heck out of him. He was a prosecutor. He's an attorney, and I went up to him the next day and I said, Senator, I hope I didn't cross the line yesterday. I hope you know I didn't mean anything to be perceived as personal against you, and I certainly respect your opinion and your passion for stating your opinion. And I hope to goodness I never have to go up against you in a courtroom. And I apologized if I was unprofessional. And his response was immediate. Hey, I get it. I feel the same way, and if I cross the line, I apologize as well. And we fist bumped because it's the days of COVID-19. And we were friends before and we're friends after, and we continued working on this bill. And I think that's the way it ought to be done, and I think we are in the right place. This bill was engrossed. It's not usual to engross bills here. Ordinarily, if it's an ethics bill or a finance bill, the Senate will do that because those can be things that blow up into all kind of different discussions and arguments that weren't considered in committee. I did not oppose the engrossment in this case because I feel like it's a very delicately crafted compromise. Those of us who very strongly support law enforcement and think it is inappropriate to intimidate or terrorize those people got our way earlier this morning in 838. And it's my understanding that is being considered by the House as we speak here. And if they agree with us that that is a category or a group of people that also are deserving of protection against hateful, biased, intimidating criminal conduct, then I feel like we will move forward with this and everybody wins. But I can see the argument that it muddied the water to take the attention off of citizens committing crimes against each other here that we're dealing with in hate crimes. And I urge the House to pass that bill promptly, and then we're going to deal on this bill. And we're really looking at a package then. Okay, I've already told you about our study committee. We're going to deal with police practices and procedures. This morning, we dealt with intimidating actions, terrorizing our own first responders, and now we're dealing with actions between citizens. So to the details of the bill, and I can be brief because it's fairly concise. I just told you the groups of individuals that we are protecting from existing crimes. What this bill does is, if it is a designated misdemeanor, and we have listed 5 of those actions on page 1. Lines 17 through 21, we've identified misdemeanor crimes, which are petty crimes. They're not serious. They cannot result in imprisonment of more than a year. But these that we've agreed upon are attacks against a person or their property that are inappropriate and that are commonly used for bias and prejudice-based crimes that intimidate others. Simple assault, simple battery, criminal trespass, and misdemeanor theft by taking. Those 5 misdemeanors, if committed because you intentionally selected the victim because they belong to one of these groups, will have an enhanced penalty. And all we're really talking about on enhanced penalty is a minimum. A misdemeanor, those 5 I just told you about, can be punished from 0 to 1 year. Can't punish you for more than a year if it's a misdemeanor crime. If it's done to target one of these groups, all this does is say it will not be less than 6 months. So we're going to make sure that your minimum sentence is at least 6 months if it was done as a hate crime, and no more than 12, because that's the maximum on a misdemeanor crime anyways. And it could have a fine in addition to that, up to $5,000. This does not require imprisonment of 6 months. A more artfully drawn clause here might say it is permissible but not required, but it may be suspended by the judge, it may be put on probation, or it could be confinement. But the sentence will be no less than 6 months. So even though the word says sentence of imprisonment, that is not mandatory confinement. I think that's important for all of us to know that. And one reason is because the NAACP is opposed to mandatory minimum sentences of confinement, because we're looking at a situation now where many more African Americans are imprisoned than Caucasians. And this might, if it was mandatory confinement, end up being disproportionately imposed. It's up to the judge, and only enhanced if the jury has found beyond a reasonable doubt that the crime was committed and that it was with this specific intent to target a certain group that we are protecting in this legislation. And it also has enhanced penalties if it's any felony offense, which by definition are more serious offenses that suffer the consequences of more than a year confinement. And different crimes have different lengths of confinement for that conduct. But here, if you commit a felony and it is for one of these, we'll just say discriminatory reasons, it will be no less than 2 years in your sentence. It could be 1 year if we didn't have this law. In this law, it will now be no less than a 2-year confinement or probation. And it can be a fine for $5,000. That's really all we're doing in the hate crime portion of this. Now, Lieutenant Governor's proposed legislation included this section 2, beginning at line 37, which deals with reporting provisions. And it requires law enforcement in their investigation to include certain things in their report. And those include the names of the parties, their relationship, their sex and gender, their race, their religion, their dates of birth, their ages, when the incident occurred. And basically, is there evidence to show that this offense that's being investigated was because of a person's actual or perceived attributes, that they were in one of these categories, let's say, or groups that we're protecting. This is important for a couple of reasons. One is to collect the data so we can learn, do we have a problem? Where is this the problem? What can we do to stop it? Are we improving? Let's hope that 5 years from now we look back and say, let's track this data. We're getting better. We're being nicer to each other. We're not attacking folks or committing crimes against them because of them belonging to any of these groups. There's also a provision that these reports are not subject to Open Records Act, because remember, these are just investigative reports. The person's not proven guilty until they have a trial. And 12 of their peers unanimously agree beyond a reasonable doubt that they did it. But it is made available to the person that's accused because it's only fair to give them this evidence. What have you got against me? Why do you think this was based on my targeting a certain group? I believe that this is well received by most parties, most people interested in this legislation. So all we're doing is requiring reporting and enhancing or increasing the minimum penalties if it's shown that you committed any of these criminal offenses covered to target these groups. I am encouraged. I went from being, I'm telling you, it was hard to sleep some nights. And I was asking committee, why now, Bill? Why are you just now starting to worry about this problem that we've been living with for our whole lifetimes? The honest answer is because of this graphic video images that we've all seen on the news now. That makes this an undeniable problem and injustice we can't continue to tolerate. And I don't know that this bill ends it. My instincts tell me no, but I think it helps. And I think it makes a statement that we don't approve of that conduct. And I think it helps move public perception and public attitudes for us as a legislature to make this statement today. So I encourage all of you to support this. There may be other speeches that folks have. You may remember some other songs that you think are important that shares wisdom, the poetry of the authors. I'm happy to answer any questions there may be, Mr. President. Otherwise, I will yield the well and ask for unanimous support of this legislation.
Senator, your time has expired.
Perfect timing.
Thank you, Senator. The chair would like to recognize the Minority Whip to speak to House Bill 426.
Thank you, Mr. President, and thank you for all the work that we've done on this particular bill. One of the things I want to do is just kind of go through it a little bit probably clinical to some extent, and then also talk about how we got here. But I did want to make mention, as we go through it, the fact that we have selected various misdemeanors to actually choose from, and to say that that is actually something that is good. These misdemeanors that we've chosen are actually the ones that will most likely be the ones that are going to be implicated, whether you're talking about assault, simple battery, criminal trespass, and also misdemeanor theft. These are normally the type of offenses that would be implicated in hate crimes. And this is just not us guessing at it. The fact is that if you look at FBI statistics, these are normally the offenses that have been reported as far as hate crimes are concerned, by a clear majority as far as misdemeanors are concerned. So what we've done is we've actually used data to actually help us get to a point to where we're actually addressing the issues that we want to address. And I want to make it known that we're not, when we use these designated misdemeanors, that we still have other misdemeanors that are out there that some may actually want to be included, such as disorderly conduct or harassing phone calls or shoplifting. But when you look at the data, and that's key, that what we've done here through this heavy lift is actually try to fashion something which is based in reality of what we're trying to do. When you look at it, those offenses really are not implicated in the FBI statistics. So by drawing down on those misdemeanors, we've actually condensed it in a way that I think fits what we normally talk about as far as doing things, from the standpoint of doing things the Georgia way to some extent. On data collection, I want to make sure that everyone realizes this is extremely important. The ADL, the Anti-Defamation League, basically has been working on this issue of hate crime since 1993. They've created the model legislation as far as hate crimes is concerned. Part of their model legislation is twofold. Number one, they say that the best legislation is going to be penalty enhancement, which I'll talk about that in 1 second. But also key is the fact that you have to have data collection to actually make a successful hate crimes legislation. We've done that. The fact is about 24 states use penalty enhancement and also data collection. So once again, what we're doing here today, when we start talking about strengthening the bill, we've done that. We actually have strengthened this bill by doing data collection. And it is important to do that because one of the things that many sheriff's offices are doing, and in fact, the sheriff's office in Richmond County has been doing, is using data to actually know where the crimes are happening. Everyone thinks they kind of have a crime problem in their neighborhood, but when you actually have that data collection to say, these are where the burglaries are actually taking place, these are where the robberies are actually taking place, you know where to actually put your resources to. So we find that law enforcement is currently using more data. So the data piece of this is important so we can know where the actual hate crimes taking place in Georgia. So it's not just a matter necessarily just collecting it in a, we want to use it against somebody. First of all, you can't because it's not subject to Open Records Act. But secondly, it's not just a matter of a feel-good thing of collecting data. It's going to tell us, number one, where the hate crimes actually taking place at. Secondly, we can divide that up in subsets as the FBI does. For instance, where the racial hate crimes taking place at, where the hate crimes as far as sex is concerned taking place at, so we can know where to actually put our resources to. So that's why that's so important. It's not just something that necessarily feel good, it's actually going to allow us to combat hate crimes in sort of a scientific kind of way. That's why that was so important to this bill, and it actually does strengthen it. The next aspect of this bill is penalty enhancement. And you can have specific offenses, and that can work, but I do want to make note that the ADL, the Anti-Defamation League, says that most of the things that they would like to do are penalty enhancements. Most of the states, almost uniform states, when they do what they call specific crimes, they focus on cross burnings or they focus on destruction of church property. Georgia already has both of those areas covered as far as defacing churches and also cross burning. We have statutes that already meet that, even though they're not within the rubric of hate crime. So when you look at other states that do what we call specific offenses, they have penalty enhancement, and what they call specific offenses normally are cross-burning offenses or things as far as defacing churches. We have those actual two areas already covered. But I also want to make an important point about penalty enhancement, because I heard some questions about that and as far as versus a specific crime and how the prosecution would work. And I think it's important to understand it from this standpoint, because it's extremely important to realize. When you're doing a penalty enhancement, don't forget, the person's already been convicted of an underlying crime beyond a reasonable doubt. The penalty enhancement can only come in also by showing the requirements for the penalty enhancement by beyond a reasonable doubt. So both require that. That's number one. There was a question about whether the standard would be different. But here's something else that's important. I think there's been some questions about, well, the evidence that would be presented in a hate crime. Would we get into like a person's beliefs or opinions? And the answer to that, when you do penalty enhancement in the principal case, is actually no. Here's the difference. When you do a specific kind of hate crime, if you were to try to say it's only done by bias, and you can work this through, but it's more difficult. Therefore, in the principal case, when you do a specific penalty, you then need to actually go into that person's kind of history, because it would be relevant to show that bias. With a penalty enhancement, the only thing you're worried about in the principal crime, in the underlying case, is the elements for the underlying case. That's it. You're not going to get into all their different opinions. It's not relevant, because what you have to show is that they committed simple battery, they committed simple assault, that they committed misdemeanor theft. That's what you have to show. When you try to do a specific intent kind of crime, your elements actually are that bias within the underlying offense itself, which means all kind of intrinsic things can come in. They have to be relevant because that's part of your case. That's the element of your case. In a penalty enhancement case, that's not the situation. The only thing that's relevant to find that person guilty of the underlying offense is what does it take to constitute a battery? That's a visible injury. What does it constitute to constitute a criminal trespass? That's going to be that you damage someone's property up to $500. It's going to work just like every single case works today. So that's actually the benefit of doing that. Can you do specific penalties? You can, but you have to be very careful how that's kind of structured. So I want to say that that's why this penalty enhancement is extremely important. It's actually going to protect defendants as far as like their personal beliefs and things like that are concerned. It will not be relevant at all in the underlying case. I cannot present that to you enough. And so we are here, and I want to say that this has been a tremendous lift that has taken place. We many times talk about bipartisan legislation. This is it. This is the definition of it. This is the definition of legislators working together with the leadership And I can't be remiss, we also want to thank the House for bringing this over to us. But with the leadership of the Lieutenant Governor, with the leadership of the Majority Caucus, leadership of the Minority Caucus, every single member here ought to be proud of the fact of what we've done here today, hopefully we'll do here today. We are setting the stage that Georgia is continually to move forward, and that we have basically shown the model of what bipartisan legislation is all about, because this was a hard lift. There's no doubt about it. Tempers flared at times. Persons got angry at times, but we always kept our focus that we're legislators. And at the end of the day, we're members of the Georgia State Senate, and that when it comes to it, we can get things done. And we have proven that by getting to this point, because there was a time over the weekend I thought our dialogue had stopped. And it was through the leadership of Lieutenant Governor that dialogue was able to be opened back up, and we got back together. That's what we're here to do. That's what the big bucks to do, so to speak, is legislate. And we've proven that we will do that, and we can do that. And I want to thank everybody who's been part of this process in moving this bill forward. Thank you, Mr. President. I yield the well.
Senator has yielded the well. The chair recognizes the senator from the 9th to speak to the measure.
Thank you, Mr. President. I'll be very brief. I do stand in support of HB 426. Make sure I get that number right. I've gotten a few emails on this over the last few days. I want to say that I'm very proud of my Gwinnett County colleague who started this debate last year, Representative Efstration. He began this last year in the House, and I was glad to be able to come to today. I think today's very important, and I'm glad to be able to vote for this bill today, and I want to thank him for his leadership on this issue. I think it is very important that we pass this today. I know that there are many people around our state. I know there are definitely many people in our communities that are crying out for something to hold on to. They're crying out for us to take a stand. I want to thank the senator from the 46th for his leadership on this issue. I want to thank you for his kind words. I spoke a few days ago about us needing to listen so that we can act. I think this says that the Georgia Senate and the Georgia State Legislature has done that. And I'm proud that we've been able to come together in order to try to move this forward, again, meaningful hate crimes legislation. I think it's important that we stand up. Senator from the 46th said it. This bill is not going to end racism. It's not going to end prejudice. But it's important for us today to say, while our actions may not end these problems, what they do say is that we're going to take a stand against these issues, and I think that's very, very important. Mr. President, I thank you so much for the opportunity to speak in favor of this. I do ask for your favorable consideration. I yield the well.
Chair recognizes the senator from the 36th to speak to the measure. There she is.
Thank you, Mr. President. Colleagues, I simply want to add my appreciation for where we have come to in this moment. I do think that this body and the Lieutenant Governor can take pride in the fact that we are coming together to do the right thing, and it's not been without a lot of anguish, a lot of incredibly hard work, nights and days that have been spent by people of both parties working to bring us where we are today. I placed on your desk an article by Mona Sharin, often known for to be a very conservative and highly esteemed writer and public intellectual. And she described how the killing of George Floyd and the video that she saw changed her mind. She traces, if you'd read it, it's a quick read, but she went through her own growth on this issue of race and what has been the history. in this country for minority populations, and in particular African American population. And she came to a place today where she says, I've changed my mind. I've thought about the narrative I used to believe in when I rejected that there was racial oppression. And I've come to understand, and I've looked at numbers and figures and listened to people. And that individual step that each of us can take, the road is there, and people come at different times to it. My Mississippi-born brother-in-law, chaplain, came to a realization that he needed to take a stand against racial oppression when African-American workers on his job shared with him what their lives had been like. If we open our ears and listen, we can come together. And you could have said a week ago that we wouldn't be here in this place today. But we're here because people opened their eyes, opened their ears, listened to each other, and figured out a path to take this very important bill. So I applaud all of those who've worked so hard on it, and hope that we can come together with a resounding yes to this bill that is before us. Thank you.
Senator has yielded the well. The chair recognizes the senator from the 23rd to speak to the measure.
Thank you, Mr. President, senators. I'll be brief. People have asked me repeatedly over the last few months, why did we not take a vote on this bill in judiciary? The easy answer to that is we didn't have the vote. It took the events that are shaking our nation and the leadership of our lieutenant governor to help forge a consensus, particularly among my Republican brethren. But I think if you look at the reason why hate crimes legislation was upheld by the courts, you can see why it's so relevant to today. Let me tell you, bias-motivated crimes incite retaliation. This leads to a cycle of violence that can spin out of control, leaving deep scars on a community that can last for generations. Former Chief Justice William Rehnquist cited these very reasons when the U.S. Supreme Court unanimously upheld Wisconsin's hate crimes bill 27 years ago. This relationship between hate crimes and civil unrest has been proven in my own community's experience, its history. 101 years ago, an incident occurred in which a law enforcement officer was shot while trying to serve a warrant. This triggered a white mob's attack on Palmer's Grove Missionary Baptist Church. They burned the African American church and lynched 3 black men, throwing 2 into the fire. It didn't end there. This incident in the spring of 1919 sparked a wave of racial unrest, senseless killing, and destruction across the country, unparalleled in our nation's history. Riots occurred in 36 cities across America. This was all chronicled in the book by Cameron McWhirter, Red Summer. Cameron sometimes reports for the Wall Street Journal here in our chamber. It was brought to my attention by the widow of the late Court of Appeals Judge Jack Ruffin. because Judge Ruffin's grandfather was father was one of the hunted persons in that incident. And had he not escaped, our Judge Ruffin would not have been here to serve our state. We have seen this pattern repeated in the 1960s and more recently in unrest in cities, including our own capital, Atlanta. One of the recent catalysts for this cycle of violence involved the shooting of a young jogger, Ahmaud Arbery, which occurred in the senator from the 3rd District. That senator sits on our committee. That same young black man is buried in my district where his family is from. This is a step in the right direction, this legislation. I want to thank Chairman Efstration for having the foresight to initiate this new hate crimes legislation. I want to thank the senator from the 2nd for contributing Senate Bill 166 to the discussion. I also want to thank our Lieutenant Governor and his team for their efforts to bring what we have before us today. And finally, I want to thank the senator from the 46th for presenting the bill. Many others have worked diligently on replacing Georgia's old hate crimes law that was struck down in court with a stronger law in its place. Legislation that will reflect the fundamental values of our state, that will target bias-motivated actions that threaten civil society, and that will respect due process and trust in the wisdom of our courts in making the punishment fit the crime. While this bill will not solve all the problems that underlie current unrest, that's obvious from the unrest we see in many of the states that already have hate crimes on their books, such as the city of Minneapolis. But it's a step in the right direction, done in the same spirit that in the past has led the Senate Judiciary Committee and this body to pass criminal justice reform, body camera legislation, grand jury reform. I could go on and on. It's not a perfect bill. It doesn't reach some of the exercise of fundamental rights, which hate can sometimes disrupt. But this is a process that we've started, and I hope we'll continue, and I urge your support for House Bill 426.
Thank you, Senator.
Yield the well.
Senator has yielded the well. The chair recognizes the senator from the 33rd to speak to the bill.
Thank you, Mr. President, my fellow senators, colleagues, friends, and the rest of y'all. I just wanted to take the opportunity to say thank you for working together, because sometimes we have to look at things from not only just a micro perspective, but a macro. Just like when you drop a rock into the water, the circles start out small, but then they become bigger and bigger. Sometimes we don't realize how just a small action today of us coming together can someday down the road have a significant impact. As a senior NC officer in the United States Air Force, I've always had to work with men and women of different backgrounds, trying to blend personal goals with organizational objectives, which is the mission. You know, it kind of reminds me of when I played in a band. When we were tuned up, we sounded horrible. But once we got tuned up and played our music, we played such great harmony. And that's what we did here today. And as a member of the Judiciary Committee, I worked closely with my colleagues trying to craft Senate Bill 426, and we were very successful at the product. But I just want to thank the Lieutenant Governor for his leadership, House Representative Efstration for bringing the bill, Senator from the 46, who over the years I've come to really develop a good working relationship with him, and I have a lot of respect for him because he showed me a lot about the ropes when I was a young freshman senator. And I just want to thank everybody. If I miss anybody, don't blame it on my mind and don't blame it on my heart. But thank you so much. And Mr. President, I yield.
Senator has yielded well. The chair recognizes the senator from the 31st to speak to the measure.
Thank you, Mr. President. When the sponsor of the bill was in the well, I pushed my button and the time ran out before he got to me and he had to excuse himself. And then the second presenter came to the well, and I thought he too, maybe even better, more so, would be the person to ask some of my questions of, but he too excused himself without taking questions. So I'll give you the questions, and if you've got answers, I'll be glad to receive them. I realize I don't take answers to questions from the well, but you can find me at my seat. The question was going to be if you could give me some examples of records in the GCI database of people who had not been arrested nor convicted. Now, GCIC stands for the Georgia Crime Information Center. That's a database relative to crimes. Now, this legislation says, if I can read it right, that if an officer responds to an instance where there may have been some bias involved, that they're to file a report. And there's a whole list of things that goes in that report. It's supposed to be used for statistical information, but your name is in there. I wondered about a pastor who preaches the Word of God from Leviticus, if you want to know where it is, relative to sexual orientation. And perhaps he does it more than once. And then the protest began. Perhaps they show up at his church. And law enforcement is called out. Will that pastor then get his name on that honored roll? So I thought about a story in the Bible. Matthew 22 and verse 35. This is not a new topic, y'all. So the lawyer went to Jesus and asked him a question. Master, which is the great commandment in the law? Jesus said, thou shalt love the Lord thy God with all their heart and with all their soul, with all their mind. This is the first and the great commandment. And the second is like unto it, to love thy neighbor as thyself. Now, I don't know when murder was put in the law. It was put in God's law a long time ago. I don't think we're doing anything, folks. This is a very complicated issue, but seem to be complicating it even more, and perhaps some feel good about that. But we are all elected as representatives of the people to go to serve in a fiduciary responsibility to make good decisions. And I just urge you to carefully read this and consider the ramifications. I think we're going to catch up a lot of people. They're going to get their name inscribed in a database with a lot of people that they don't want to be associated with. Thank you. I'll take any questions since no one else is man enough to do that.
You have no questions.
Thank you.
Chair recognizes the senator from the 15th to speak to the measure.
Thank you, Mr. President and members of the Senate. I just wanted to be very brief in my comments and express to you my sincere appreciation for the great work in coming up with this bill that hopefully will have a healing factor and send a signal to those who would think of us otherwise as a state that's willing to roll up our sleeves and work hard to come together when a crisis occurs. And let me not forget to thank the President, our Senate leader here. Thank you very much for the work you did on this bill, sir. Appreciate you, Senator from the 46th and the Senator from the 22nd, and all of the senators from the 26th and the 22nd as well, and all of the senators who rolled up their sleeves and got together, even when perhaps it was a bit painful to craft this legislation or redesign it as a representative of the audacity of hope. Hope that we can come to the table and address real critical issues that's affecting our state. Thank you for contemplating beyond your own scope. The spirit of mankind is great, and if we kindle that and nourish it, it will grow beyond our own thinking, our own selves, our own aura of what we're about. Just lend a hand to somebody else's problem. I believe this represents great hope, great belief that we can help each other change and be better for it. Georgia is a great state, and we can do what Maynard Jackson talked about years ago. Be not a city, but a state too busy to hate. Let's embrace this and move forward. Thank you for your time. I yield the well.
Thank you, Senator. The chair recognizes the senator from the 35th to speak to the measure.
Thank you, Mr. President. I stand today asking everyone to give an affirmative vote because hate crimes have been in existence forever, especially my entire life, because at age 12, I was accosted just a few miles from here, standing across the street from my elementary school. I had worked on a project, and my sisters had been picked up, and I had to catch the bus to my mother's school where she taught. So I was standing there with my little uniform on, and this group of young men from a nearby college, and some of you graduated from there, so I won't say the name of it, but they pulled up and started calling me the N-word, right across the street from Ebenezer Baptist Church, too, right there on the corner of Boulevard and Auburn Avenue. The nonviolent person that had been fighting for civil rights. But they started screaming. They threw a Coca-Cola bottle at me. And I started bleeding, and it was a little store there, and the man ran out and told them to get away. They speeded off, and guess what? Less than a few feet away, they hit the curb, and the car turned over. Nobody was killed, but they were banged up a little bit. But this is in a city too busy to hate.
So I have also experienced it even right here when I was the second signer with Vincent Ford on the last hate crime bill. And one of the high officials here said to me, "Why do you just keep bothering that? Let that die." And then I told him why, and he said, "Oh, cry me a river. How many times will we be blamed for the sins of our fathers?" And this is the mentality we had then, and we did pass a bill, but of course it was struck down because it got gutted before it got signed. So, yes, I personally stand for this because I was in the center of nonviolent demonstrations and protests. I was too young to participate in the civil rights movement, but I stood on the sidelines, I watched, I learned, and I cheered on those who did fight for us. So I will take my seat and just encourage you here in Georgia to pass this bill because, yes, we are one of the only states that does not have a hate crime bill. And given recent events, such as the murder of Ahmaud Arbery and the other young black man who's being buried today, they were both pursued and fatally shot. There is immediate need to pass out a strong hate crime bill. I was the second signer, as I said, on that original bill. Back in 2000 and 2002, that bill ended up being stripped down, ruled too vague, and unconstitutional. But I'm so grateful to all of you because now we have a possibility to pass this very important legislation today. We must all stand united against targeted violence and bigotry. Victims need protection against any attack motivated by hatred due to bias or prejudice. So House Bill 426 is a measure approached at doing all of the things that we need to do to treat this injustice. It's time that Georgia rise up and show that we will not stand for crimes done out of hate. Yes, we cannot legislate love, but we can put stronger penalties in place that may deter those who are committing these crimes from doing it. So I take my seat and I'm reminded of Nina Simone, who sung about strange fruit, and that was, of course, people being lynched. They're still being lynched. Racism, bigotry, hatred still exist. Let's do something in the state of Georgia to try to curb that. God bless you all. God bless the great state of Georgia. And I yield the will.
Senator has yielded the well. The chair recognizes the senator from the 45th to speak to the bill.
Thank you, Mr. President, members of the Senate. I rise, and I have to apologize if I seem a little bit nervous, because I am very nervous. I guess you'd call it the proverbial cat on a hot tin roof. I feel like I'm on a hot tin roof. And I think my trepidation is because it's not about the bill. It's about the method to the madness of the bill. And I feel really bad about that. I feel real bad about it.